A wise man once said that the best way to know a man is to observe him and keep records of what he does. It's on this note that I welcome you to a new day on Signature Television. My name is Godwin Sunday. Today we'll be talking about an issue that concerns everybody. For as long as you're an adult and it concerns you, and this issue is the issue of housing in Nigeria, and more especially when it has to do with people that stay in rented apartment. Now you need to join in this conversation because we need to cross all the T's and dot all the I's that concerns real estate and rent issues in Nigeria. And joining me in this conversation this morning is Barrister Zach Okoronkwo, who is a PhD holder when it has to do with real estate and property laws in Nigeria. So you're welcome to New Day, Barrister Zach Okoronkwo.
Thank you, Godwin. It's my pleasure to be here.
All right, thank you so much. So let's even start the conversation around documentations first, before we even delve into the rent issues in Nigeria. Now, we understand that most people acquire properties in Nigeria without even understanding what documentation entails. But you are in the field and you happen to be a legal practitioner. So what kind of documents is valid for one to acquire properties in Nigeria?
Thank you once again, Godwin. Thank you for having me. You know, this is very critical issue. Issues of property acquisition in Nigeria is being misconceived. A whole lot of people make mistake in this area. Very critical. I see a lot of people well enlightened, very prosperous people who you think that are very knowledgeable. But when it comes to acquisition of property, you see them, they buy property, they can afford to buy very expensive property, they spend huge sums of money to acquire property. But when it comes to documentation, which is the foundation of the acquisition, they gloss over it, they trivialize it. It's very serious matter. In Nigeria, because usually people easily assume, make assumptions that what they're buying is valid, and in most cases they buy valid property, they acquire properties that are valid. But wherever there is an issue in documentation, it could be catastrophic, it could be harmful later in the, because like for instance, I give an example. I've had cases where a brother sold a property to his own brother. It's a gentleman's understanding, gentleman agreement. They are both of them are brothers, biological brothers. They trust each other. There is no problem. But way down the line, maybe in the next 20 years, in the next 30 years, where after they have gone, after they are no more, the family have expanded, issues could arise among their successors in title. Property acquisition is sometimes an investment of a lifetime that can transit beyond an individual. When they acquire property and on a gentleman understanding, after many years, issues can arise over that property, and they come back to square one. The issues, was that property well acquired? Were there issues in acquisition? So back to your question, when you buy property in Nigeria, make sure that you don't buy. It shouldn't be an oral agreement, because people think that it could be oral agreement. You must have the need to consult a lawyer from day one. A lawyer must advise you first of all, on the property, the validity of it, or otherwise, a lawyer must conduct the due diligence search. Conduct search. A lawyer should be able to give a search report, written search report, that this property is valid, and you are relying, based on that, you are relying on the professional competence of that lawyer, and then before you now decide to buy. And when you decide to buy, certain documents must be there. In Nigeria, acquisition of property particularly is centrally governed by the Land Use Act. The Land Use Act said interest in person, because that's not like buying of property. You don't buy property, but you acquire interest in property. That is to say, interest can, the Land Use Act said that for interest can transfer from one person to another by deed. By deed. Question: what is it? A deed is a document signed, sealed, and delivered. a document signed, sealed, and delivered is a deed. So you must acquire property by deed. Anything, if like there are situations where people buy property and they sit down and write agreement. They even write something like what they call memorandum of understanding. This is a worthless when it comes to acquisition of property. You can even buy an aircraft with a receipt of payment. Somebody can give you a receipt and you buy an aircraft, an aeroplane, or a ship that is much more expensive. But you can't buy a property of 1 million naira, even a property of 10,000 naira by another agreement. You can't acquire interest in a property by mere agreement. It must be by deed. A deed is a document signed and sealed and delivered. That's a deed. So you must, this is the work of a lawyer. You must get a lawyer. You must seek legal counsel, legal opinion, legal advice. A lawyer must do documentations for you. You know, there are different kinds of deed. There's deed of assignment. There's a power of attorney. Power of attorney is a deed. You know, there is a deed of conveyance. There's deed of that. You know, but it must be by deed. The question, you acquire interest in property. Interest can move from one person to the other by deed, only by deed, and nothing otherwise.
Interesting conversation, Barrister Zach. Let's come back to the issue of rents in Nigeria. You agree with me that the rent right now is skyrocketing, and you have mentioned right documentation.
Yes.
But let's start with, what are the factors that you think are making properties to skyrocket and even rents to shoot up, even in the country right now?
There is nothing other than particularly scarcity. But back to it, is a holistic problem, it's a general problem. There's inflation in the country. Everything is skyrocketing. It's not just rent. Everything skyrockets. Even the biscuit in the market is sweet. Skyrocket. You know, little children cannot even buy sweet anymore. You know, those days we used to buy sweet. When we go to school, we buy sweet. Everything, cost of everything has gone high, including rent. Shockingly, do you know what? Yesterday, a client called me and told me that she wanted to rent her apartment, a one-room apartment at Zone 2. I asked her how much. She said 2 million naira. I said, one room. You know, this I'm aware. I practice in Omuahia, I practice in Port Harcourt. You know, in Omuahia, you buy a property, you acquire full ownership of a land for 2 million naira or less. But in full ownership
okay,
of less than 2 million naira or less. But yesterday I was shocked when a client told me that she wanted to say that she wants to rent one room self-contained. I asked her how much. She said 2 million naira, and she means it, and somebody will take it. So it is apart from general skyrocketing of price of things. Abuja is a peculiar case where the cost of rent is horrendous. I keep thinking, how do civil servants survive? And that's it comes back to the issue of corruption. You can't survive in this country without corruption. Let's be just honest with ourselves. Corruption is almost inevitable. I get scared when people say they are corrupt.
We'll come back to that,
yes.
Mr. Zach. We'll come back.
Things are quite expensive. Real estate, particular property, rent here in Abuja, particularly, and in Lagos and in some other cities, are quite exorbitant. The cost of rent is high, horrendous, you know, and it's amazing, but it's just like everything. But talking about the cost,
Mr. Zach, at this point,
yes,
the rent is going up. Well, most of these houses were not built yesterday.
yes,
Some of these houses were built some 15 years ago.
yes,
Built, delivered, sealed and delivered.
yes,
But right now, the landlord keep increasing the rent.
yes.
Can one say that this is wickedness on the part of landlords?
I wouldn't want to hold briefs for the landlords, but the whole truth about it is that you can't call it wickedness. It's a holistic issue. You can't pick and choose. You can't separate. Like a landlord, and everybody. If you just every one of us is a potential landlord. If you don't own a house, you hope to own a house. If you look at Maslow's a lot of needs, housing is shelter, is a critical need of man. Every man hope to own a house, and if you own a house, you become a landlord. So if you condemn landlords, you condemn yourself. The whole truth is that everything is expensive, horribly expensive, and that's what comes back to the issue of government. That's why we need government. We need government to question this effect. That number one, there is inflation generally in the country, and particularly there is scarcity, dearth of affordable houses. It brings us back to the issue of mass housing scheme, which should be at the epicenter of government policy, every meaningful government policy. And let me tell you the whole truth. In several parts of the world, housing, real estate particularly, has been an instrument of revitalizing an economy, especially an ailing economy. When an economy is ailing, the government should step in and revitalize its economy using the instrumentality of real estate, particularly mortgage. Mortgage is a subsector in real estate. Mortgage is an instrument that government can use adequately to revitalize its economy by focusing in development of mass housing scheme. And I don't want to praise anybody, but one of the projects of this current administration is on housing. But the question is that what they are doing yet is also is almost inconsequential. I saw something about a building of renewed hope cities and estates, which is ambitious to build about 100,000 housing units. It's a tip of the iceberg. It's not here anywhere, and the government has not even achieved that. But at least is a way forward, and we need to encourage the government to focus on developing mass housing scheme. Mass housing scheme is very, very important. It creates jobs. It creates opportunities for it stabilizes the economy in a whole lot of ways. It creates employment and all that. And people need to live in decent houses, to be able to think well, organize themselves, and be able to project and affect the economy and pay stars. They pay stars and affect the economy positively. Mass housing scheme is a very laudable initiative that must have to be encouraged, and this can be achieved through mortgage. And particularly creating awareness. Another thing is not just having good policies, creating awareness, social awareness. People who are potential beneficiaries should know about these policies and should be able to access these policies, and that can help our economy.
Barrister Zach, there is this misconception,
yes,
that a tenant cannot sue the landlord over issues of rent. But you are a lawyer,
yes,
and you've been in the legal space and been in the property law space for a while.
Yes.
Educate us on this. Is at what point can a tenant sue the landlord over rent issues?
Okay, let me tell you the truth. When it comes to rent is purely contractual. It's a contract. It's an aspect of contract law. It is actually an aspect of contract law. Rent is a contract. If you take lease of a property, you have established a contractual relationship with the landlord. The landlord, or both of you vice versa, you have a contractual relationship. That's why we have tenancy agreement. Tenancy agreement is a contractual document. Either parties can sue the other. The landlord can sue, the tenant can sue. But in most cases, particular cases, is actually the landlord. What we see here every day, we go to court, what we see is recovery of premises, whereby a landlord seek the courts to make an order, to him to recover his property. That's the usual thing. But in ideal, a tenant can also sue landlord. A tenant can sue landlord for various reasons, even arbitrary increase of rent. When a landlord wake up in the morning and increase his rent, a tenant has rights to sue the landlord. Increment must be reasonable. That's why we have rent control acts. We have rent control laws of different states. There are laws, because again, when it comes
is that law applicable to Abuja?
It's existing everywhere.
Okay.
I'm
just curious if it's applicable to Abuja.
The law particularly seeks to protect the interests of a tenant. A tenant must be protected, just like in husband, in family, domestic issues, husband and wives. The law, the Matrimonial Causes Act seeks to protect the interests of the wife more than that of the husband. That's ideally. But in landlord and tenant relationship, the law seeks more to lean more on the side of the tenant, protect the interests of the tenant, because the tenant is dangerous when a landlord wake up and throw the tenant's property and on the street. When the tenant can constitute nuisance, can become a nuisance to the society and all that. So the law tries to come to play to protect that from happening. But the law is a two-way thing. It's for everybody. It's a three-way traffic, as a matter of fact, for the state, and for everybody. So the law protects both. But with the point I'm making, back to your question, is that any one of them can sue. Once there's a valid tenancy agreement, even if when there's no valid tenancy agreement, any one of them can sue. Tenancy can be created orally. There's already a lot of payroll agreement. A payroll agreement is as good as binding as good as written agreement. Most tenancies are not written down. There's no tenancy agreement, but it's still guided by the law. If there's any infraction by any of the parties, the other party who feels aggrieved can initiate an action. But in typical cases, in most cases, it's the landlord that goes to court trying to eject.
Barrister Zach, let's talk about the issues which you've raised right now. Is there a time frame for a landlord to increase his rent? Is that supposed to, does the law gives a place a stipulated time for a landlord to increase rent, even here in the Federal Capital Territory? Because I know a lot of people in Abuja right now are eager to hear the side of the law on this matter. So please enlighten us on this.
Of course, a landlord cannot wake up in the morning and increase.
So is there a duration? So once I'm acquiring a property in Abuja, I know that between the next 1 year.
Let me tell you.
Okay,
let me tell you. When you acquire interest in a property in terms of lease, like tenancy, what we call tenancy, you have documents. You have tenancy agreement or lease agreement. Those the agreement will specify what you want. That's why you need a lawyer to prepare a valid
so in a case where it's not specified,
you can stipulate that the landlord cannot increase his rent till after. I did one recently. We said 5 years. I said within 5 years that this tenancy is renewable after 5 years. So in that case, a landlord cannot renew his tenants no matter the inflationary the situation or a landlord will not renew his tenancy within that 5 years, or you can specify 10 years. In some cases, we've done a lease agreement where we say for the next 20 years, this tenancy shall not be renewable, or it shall be renewable after 20 years. While we will not say it shall not be renewable, we say that it shall be renewable after each 20 years. In that case, a landlord is hamstrung, cannot wake up and renew his tenancy till the expiration of 20 years. But again, one has helped calls to evaluate that can parties by agreement circumvent the operation of the law. Question is that where the law says that a landlord can increase because in some rent control acts, some rent control laws of different states, there are some situations where a law made by the House of Assembly can say that rent can be increased every 2 years. But now if parties come to an agreement, agree that they will not increase this particular lease for the next 5 years or the next 10 years. Question which one supersedes? There's a conflict between the law and their agreement. But it's a contractual thing. Parties are bound by their agreement, especially when it's reduced to writing. The court should enforce what is stated. But it's not a clear, it's not a clear situation. But the whole truth that landlord can increase his rent, so far as it is not the agreement stipulated by both parties, consciously entered by both parties, are adhered to. If they agree that it cannot be renewed, or rather this agreement shall be renewable after every 10 years, parties are bound not to renew. The implication is you cannot renew or you cannot increase or reduce. There's not like a reduction. Usually the question is always increase. You cannot increase until the expiration of that 10 years. After 10 years, you can renew the tenancy, and in the course of renewing the tenancy, you increase the rent. But again, a landlord can give notice of increase to a tenant, saying that in the view of the circumstances or situation on ground, the economy has and all that. Please, I want to let you know that I'll be renewing the cost of my...
Wouldn't that amount to a breach of contract?
It can amount to a breach of contract, particularly where the increase is unreasonable. But in most cases, there has been increase that is unreasonable. Where assuming you are paying something like 1 million naira, per annum. And landlords tell you that things have changed and all that, and that this rent is not 20 million naira. You know, a court can hold that increment is unreasonable. You know, and you can say that but after the expiration of your rent, that will be collecting 20 million naira, or anybody who does not want to pay should pack out. You know, that happens all the time. You know, his lawyer will write to you and tell all the tenants that after upon the expiration of your current lease, that our rent has increased from 1 million naira to 20 million naira, and if you are not able to pay, I will advise you to pack out. You know, one, that letter has served as quick notice in the first place, and again, it has also, you know, so you as a tenant, you can look at it and say that this increase is unreasonable. You know, when I came in here, we agreed. We have a tenancy agreement says 1 million naira. Now he woke up and is telling me that it's 20 million naira. Where will I get 20 million naira from? You can go to court asking that the court should make a declaratory order declaring that increase is unreasonable. You know, you have right as a tenant to go to court, to approach the court, and the court can look at it, look at the circumstances, look at the situation, and say that this increment is unreasonable, and the landlord cannot enforce it, that it should not be in. Like the court can hold that you continue to pay your 1 million naira. But whereby an increase is reasonable, assuming there's epidemic, there are issues that happen that to warrant a landlord making reasonable increase on his tenants, it can, and again, approach matters. You know, that's why we have ADR most times. You know, we can say that in view of the circumstances, and although we agree that your rent is 1 million naira, but in the circumstance now, we are thinking that we have to increase our rent to 2 million naira or to 1.5 million naira. We urge you to bear with us, you know, and all that. You can have a meeting and have a real understand and review. You know, most contracts are sacrosanct, but then there could be room for variation. Depends on who drafted their agreement. There could be room for variation.
But when there's a counter offer at this point, won't automatically it voids the initial contract?
Not that you can't just void the initial contract when the initial contract was well executed. No, but if further negotiation will not void the initial contract. But when you later agree, you have an understanding, you know, and reduce it, possibly execute a second agreement, it will not set aside the earlier agreement, and the content of the second agreement will contain all that. You know. But in most cases, people are advised, when it comes to issues of landlord-tenant relationship, you must have a lawyer. You must consult a lawyer. You must rely on a lawyer. You know, a lawyer should be able to know what increase that is reasonable.
All right. Barrister Zach, let's even look at this scenario where you moved into a property and there was a valid tenancy agreement.
Yes.
And in the space of 6 months,
yes,
the landlord walks up to you, which is like normal trend right now in Abuja. The landlords allow you to stay for 6 months and thereafter they increase their rent. In such a scenario, what can a tenant do?
Approach the court, nothing more. Approach the court. He does not have that.
You know, because Abuja landlords won't even tell you move out. No, if you like the way you just put it now, you just make it subtle. Abuja lawyers will tell you if you can't pay, pack out.
No, there's nothing like that. There's nothing like that. One is these are statutory.
Abuja landlords, yeah,
provisions in the law that says if you're a monthly tenant, which of course these days there are hardly monthly tenants again. Most tenants are like annual tenants. You are entitled to 6 months notice. It's a statutory notice. You are entitled to 6 months, except where you are in default of rent. That's very important. It's an exception under the law. If you're in default of rent, you may not be entitled to that 6 months notice. At that point, you become what we call a tenant at will. A tenant at will. And in that case, you are no more entitled to 6 months notice. The landlord can just give it 7 days notice. But where you are not in default of rent, no, everything is well. Landlord just said pack out. Well, you are entitled to 6 months notice. If you are an annual tenant, if you are a monthly tenant, you are just entitled to 1 month notice. But if you are an annual tenant, which is the usual case here, you are entitled to 6 months notice. So, and after that 6 months notice, you are also entitled to what we call 7 days owner's intention to recover possession. And after that 7 days owner's intention to recover possession, you also the landlord must serve you with a plaint, asking you to come to court to say the reason why you will not pack out. It's when you get to court that the process will now start. You know that you're in the process of eviction. But if the landlord does his things very well, one, we should have it in mind that a landlord is entitled to his property at all times. He's entitled to. He's a landlord. When a landlord invests in a property, it's an investment. He's entitled to returns on investment. Where you're not able to pay, he has the right to kick you out. But that must be done following the due process of the law. You need sufficient time. Mistake people make. People are always misguided, thinking that when your landlord gives you 6 months notice and that you're not going to pay rent again. That is not true. Once your tenant is determined, once you are given notice to quit, what we call quick notice. Once you are served with quick notice, your tenancy is determined. That is, your tenancy stop to exist. But the money you are entitled to pay, you must pay it even upon vacation. When you until you vacate the property, you must pay the landlord. Now it's called that. It's no more called rent. It's called what called mean profit. Mean profit is called mean profit. But at the end of the day, you pay. The court will also order you to pay everything. They'll calculate it. You pay as mean profit. It's no more rent.
All right. So just before we even go on a short break right now, and I let you go. Can a verbal what do you call it?
Agreement.
Eviction, probably.
Eviction.
Yes, probably what the termination of your tenancy. Can it also serve as a quit notice?
Let me be frank with you. There is nothing. Of course, it can.
Because we have a situation where you got your landlord.
What the law requires is that a landlord should give you quit. Assume you're a annual tenant, yearly tenant. The law requires that a landlord should give you 6 months notice.
So in a situation where
he does it orally,
yeah,
it becomes difficult for him to prove that he has given you that 6 months quit notice. So that's why it's in the interest of the landlord to reduce it in writing. Serve you with 6 months quit notice, written 6 months quit notice. Because if he says it orally, it becomes a evidential issue. When you get to court, he said that I told him I gave him 6 months notice orally. It's neither here nor there. The chances of why the law requires that it must be written in writing for evidential value. If it's not evidenced in writing, it could be difficult for the landlord to prove that he has given 6 months notice.
This is quite interesting, Barrister Zach Okoronkwo. But at this point, I want to say thank you so much for throwing light on these issues. Even as we begin to talk about rent issues in Nigeria and going forward, and how we can be able to, as a people, grow the system and ensure that we are able to provide more better housing scheme from the government. I want to say thank you so much for coming to New Day on Signature Television.
Thank you.
All right, well, viewers, this is how far we can go this morning. I want to say thank you so much. Do remember to follow us on all our social media handle. My name is Godwin Sunday. From all of us here in the studio, it's bye for now.